When two parties are in a dispute, it's entirely normal for their lawyers to have a without prejudice conversation to canvass the possibility of settlement. That's what happened in this case. One lawyer, McDonald, spoke to a younger, more junior colleague on the other side. What happened in that conversation is a matter of dispute. According to McDonald, the younger lawyer told him that there was no prospect of negotiations towards a settlement. According to the younger lawyer, he said no such thing, and in fact emphasised that they considered the matter was one which could be settled. There was an exchange of emails where each party gave their version of the phone call. Then McDonald wrote an email saying, "It is unpleasant to describe the younger lawyer as fundamentally dishonest, and it is a slur on his career as a lawyer that he starts off at an early age of his career telling lies. It is fundamental to the smooth operation of the legal system that people act with integrity and honesty, and the younger lawyer should be counselled to do this." The other side protested, and he doubled down, saying, "I stand rigidly by all the statements that I actually made about the younger lawyer. Indeed, I will repeat the statement that he was dishonest. The dishonesty was deliberate and calculated." The other firm complained to the Law Society, who found that McDonald had breached the duty to maintain the integrity and reputation of the legal profession by failing to ensure that his communications with other practitioners were courteous and/or by avoiding offensive or provocative language or conduct. McDonald appealed, and ultimately the matter came before the full bench of the Victorian Supreme Court. They applied the test in a case called Lander, where the court was to consider not only the nature of the words, but also whether they advanced the client's cause. They said, the accusations McDonald made were not merely an example of ineffective advocacy in an attempt to further the client's matter. Rather, they were sufficiently extraneous to the legitimate pursuit of the client's matter to fall outside the privilege, because at the time they were written, they served no purpose other than disparaging the younger lawyer. So, while great latitude is allowed in order to conduct strong advocacy, discourtesy will only be tolerated if it genuinely advances the client's cause.